Firstly, we will try and understand the meaning of labor legislations. The term labor means the workforce who works for compensation, and legislation means law which has been enacted by a legislature or other governing body. Thus, labor legislation means rules made by the governing body for the protection of labor. Various types of laws enacted by different governing bodies under this are the Workmen's Compensation Act 1923, the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, the Employee Provident Funds Act 1952, the Payment of Gratuity Act 1972, the Employees State Insurance Act 1948. We will discuss these acts one by one. After studying this lesson, you will be able to discuss the major provisions and related concepts of the Workmen's Compensation Act 1923, the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, the Employee Provident Funds Act 1952, the Payment of Gratuity Act 1972, the Employees State Insurance Act 1948. So let's start with the first act, the Workmen's Compensation Act 1923. It extends to the whole of India. It came into force on the first day of July 1924. All establishments hiring 20 workers and above must compulsorily register themselves under the Employees State Insurance Act or ESI Act. It is only those establishments which employ a lesser number of workers and therefore do not come within the purview of the ESI Act that the Workmen's Compensation Act applies to. The purpose of this act is, if personal injury is caused to a workman by accident arising out of and in the course of his employment, his employer shall be liable to pay compensation in accordance with the provisions of this act. The amount of compensation varies from type and situation of injury. Some provisions under the Act are: application for claiming the compensation to the Commissioner for Workmen's Compensation should be within 2 years from the date of the accident. The employer is bound to report to the Commissioner fatal accidents and serious bodily injuries within 7 days of such an event. In case of contract workers, the principal employer is liable to make payments to the worker and he can recover the same from the contractor. A worker can file the case in High Court against orders of the Commissioner if dissatisfied with the award. A worker has the right to approach the civil court directly instead of approaching the Labor Commissioner in the first instance. Now let's discuss the second act, the Payment of Wages Act 1936. The purpose of this act is to ensure regular and timely payment of wages to the employed persons, to prevent unauthorized deductions being made from wages and arbitrary fines being imposed on the employed persons. The Payment of Wages Act 1936 is the central legislation which applies to the persons employed in the factories and to persons employed in industrial or other establishments specified in subclauses A to G of Clause 2 of Section 2 of this Act. This Act does not apply on workers whose wages payable in respect of a wage period average Rs 1600 a month or more. As per this Act, wages means all remunerations, whether by the way of salary allowance expressed in terms of money or capable of being so expressed. It includes any remuneration payable under any award or settlement between the parties or order of a court, any remuneration to which the person employed is entitled in respect of overtime work or holidays or any leave period, any additional remuneration payable under the terms of employment, whether called a bonus or by any other name, any sum which by reason of the termination of employment of the person employed is payable under any law, any sum to which the person employed is entitled under any scheme framed under the law for the time being in force, Its provisions are: the salary in factories or establishments employing less than 1,000 workers is required to be paid by 7th of every month, and in other cases by 10th day of every month. A worker who either has not been paid wages in time or an unauthorized deductions have been made from his or her wages can file a claim either directly or through a trade union. The power for hearing and deciding claims under this Act has been vested at present with the presiding officer of a labor court. It is obligatory on every person responsible for the payment of wages to fix periods in respect of which such wages shall be payable. No wage period shall exceed 1 month. Deductions authorized from wages under the Act: fines, deduction for absence from duty, deductions for damage to or loss of goods expressly entrusted to the employee for custody, deductions of income tax payable by the employed person, etc. Now the turn comes for Minimum Wages Act 1948. This Act extends to the whole of India. It was passed in 1946 and came into force with effect from 1948. The objective of the Act is to ensure a minimum subsistence wage for workers. The Act requires the appropriate government to fix minimum rates of wages in respect of employment specified in the schedule and review and revise the minimum rates of wages at intervals not exceeding 5 years. The important provisions are: the minimum wage rates are reviewed at intervals not exceeding 5 years. This means that the minimum wage rates are subject to revision even before 5 years. Minimum wages are fixed for all categories of employments, viz. fixed rate, hourly rates, piece rate, and for every worker, that is, adults, adolescents, child, and apprentice. This is done as per the states. However, different rates can be fixed for different districts. The minimum rate of wages is related to the cost of living index. In fixing minimum rates of wages, the appropriate government can follow either of the two methods described below: committee method, notification method. Penalty for this Act can be stated as under: an employer who pays less than the minimum rates of wages shall be punishable with imprisonment up to 6 months or a fine up to ₹500 or both. The fourth Act is the Payment of Bonus Act 1965. It extends to the whole of India except the state of Jammu and Kashmir. The Act is applicable to every factory and establishment employing 20 persons or more or any day during an accounting year. Its purpose is to provide for the payment of bonus to persons employed in the certain establishment on the basis of profits or on the basis of production or productivity and for matters connected therewith. Provisions under the Act are: every employer has to determine his gross profit, and from such gross profit certain deductions are to be made. The gross profit less deductions is called available surplus. Employees drawing monthly salary, basic plus DA only, up to ₹3,500 are covered by the Act. The Act provides for a minimum bonus of 8.33% and maximum of 20% of the salary. An employee shall be disqualified from receiving bonus under this Act if he is dismissed from service for fraud, riotous or violent behavior while on the premises of the establishment, theft, misappropriation or sabotage of any property of the establishment. Bonus is to be paid within a period of 8 months from the close of the accounting year. The next topic is the Employee Provident Funds Act 1952. It extends to the whole of India except the state of Jammu and Kashmir. Its purpose is to provide for social security benefits for workers and their families. It applies to every establishment which is a factory engaged in any industry specified in Schedule 1 and in which 20 or more persons are employed. To any other establishment employing 20 or more persons or class of such establishments which the central government may by notification in the official gazette specify in this behalf. Important provisions under this Act are: if the employee is transferred or leaves the establishment, balance of his Provident Fund account is transferred to new account in the new establishment. There are provisions of advances under the scheme. A non-refundable withdrawal can be made from Provident Fund account for house building or for financing LIC policy or for certain illness of the member or his family. In case of default from the employer's side, the Central Provident Fund Commissioner may decide to recover the money from the employer as per the following methods: by issuing of certificate to the recovery officer, by recovering money from the debtors of the employer. Employer's money lying in any court can be adjusted for Provident Fund dues subject to the permission of the court, by attaching and selling of movable or immovable property of the employer. Another two sub-schemes which come under it are Employee Pension Scheme, Employee Deposit Linked Insurance Scheme. Under the Employee Pension Scheme, members will get pension or superannuation or retirement from service and upon disablement during employment. Family pension will be available to widow or widower for life or till he or she remarries. In addition, children will be entitled to pension up to 25 years of their age. While the purpose of Employees Deposit Linked Insurance Scheme is to provide life insurance benefits to employees who are already covered under PF or FP. Now let's discuss the payment of Gratuity Act 1972. It also extends to the whole of India except Jammu and Kashmir. The main purpose to gratuity scheme is to serve as instrument of social security for employees whose means of earning has stopped. The Act is applicable to all establishments employing 10 or more workmen or had employed on any day of the preceding 12 months. The Act is applicable to all employees irrespective of the salary. Provisions of the Act include: gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years, on his superannuation, on his resignation, on his death or disablement due to accident or disease. Gratuity is calculated as numbers of completed years of service or part thereof in excess of 6 months into last rate of wages for 15 days. Wages means basic plus DA plus other emoluments excluding bonus, commission, HRA, overtime and any other allowance. The maximum limit on gratuity payable shall not exceed Rs 3,50,000. The employer is bound to pay the gratuity within a period of 30 days from the date of its becoming payable to the employee who is eligible, even if an employee fails to make an application to that effect. Any offense by employer under the Act shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 10,000 rupees or both. The next is Employees State Insurance Act 1948. It extends to the whole of India. It shall come into force on such date or dates as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of this Act and for different states or for different parts thereof. Its purpose is to provide a scheme of health insurance for industrial workers. The applicability of this Act occurs under situations: all factories, excluding seasonal factories employing 10 or more persons and working with electric power; all factories, excluding seasonal factories employing 20 or more persons and working without electric power; any establishment which the government may specifically notify as being covered; shop employing 20 or more persons. Provisions under the Act are: establishments covered under this Act must apply for registration within 15 days from the date of application of this Act. An employer who fails to pay his contribution within the period specified shall be liable to pay interest and damages for late payment under this Act. The employer is prohibited from dismissing or discharging employees during the period the employee is in receipt of any benefit under the Act, and such dismissal would be void. Disputes or claims arising out of this Act shall be referred to ESIS Court. The statutory registers to be maintained under the Act are Register of Employees, Accident Book, Inspection Book. Penalty for the Act are: for employees' contribution there is imprisonment for minimum 2 years to maximum 5 years and or fine of rupees 25,000. For employers' contribution there is imprisonment for minimum 6 months to maximum 3 years and or fine of rupees 10,000. Now let us check if we have understood the various concepts discussed in this lesson clearly. The gross profit less deductions is called available surplus. Right or wrong? Right. The purpose of employees' deposit-linked insurance scheme is to provide deposit benefits to employees. Right or wrong? Wrong. The Payment of Wages Act 1936 is a central legislation which applies to the persons employed in the factories and to persons employed in industry. Right or wrong? Right. Now let's revise the whole concept. The Workmen's Compensation Act was passed to impose statutory liability upon an employer to pay compensation to the workman when the workman suffers from physical disabilities and diseases during the normal employment tenure. Payment of Wages Act was passed to ensure regular and timely payment of wages to the employed persons to prevent unauthorized deductions being made from wages. The Payment of Bonus Act was passed to provide for the payment of bonus to persons employed in certain establishment on the basis of profits or on the basis of productivity. Employee Provident Fund Act was passed to provide for social security benefits for workers and their families. Gratuity is a retirement benefit. It is a lump sum payment made by an employer to an employee in consideration of his past service when the employment is terminated. The main purpose to gratuity scheme is to serve as an instrument of social security for employees whose means of earning has stopped. Thank you.